Hi, everyone. Thanks for being here today. My name is Nisha Ajmani. I am a staff attorney at Housing and Economic Rights Advocates in Oakland. We're a nonprofit law office, and we provide services to low-income folks throughout the state, but primarily in the Bay Area, though we are able to provide some assistance remotely to people as far as Southern California and Northern California near the border with Oregon. So I focus on tenants' rights, and actually one of my coworkers is here on this call, Johanna Kane. She's also a staff attorney who helps out with our tenant advocacy work. So we do work in the tenant space related to all sorts of issues, including habitability problems, landlord harassment, a lot of the issues we'll talk about today, security deposits, other types of disputes with landlords, fair housing, housing discrimination. We don't provide eviction defense services in court, but we try to do our best to help people understand what their rights are when it comes to eviction and do what we can to prevent eviction if that might be something that the landlord is trying to do. And then we'll refer folks appropriately for eviction defense services if they have received a notice or a summons and complaint. And HERA also does provide legal services on other issues, including home ownership issues, mortgage, foreclosure, student loans, debt collection, credit reporting, which Johanna and I also help with if it's a tenant who's having debt collection and credit issues. And what else? We have a small trust and estates practice, and I'll provide our contact information at the end. But yeah, obviously I won't be getting into those other issues, but I just thought I would share what other work HERA does. What else? If you have any questions, I did build in some time at the end to ask questions, but you can, if you'd like, put some questions in the chat. And depending kind of timing, I'll see if I can answer some. Just make sure they're not personal questions or about a specific client case. If you do have a personal question about an issue you're dealing with or about a client, you're welcome to call our office. And again, I'll have that information at the end. Okay, so here's our agenda for the day. Oops, sorry. So we'll start off with basic tenant rights, including habitability, landlord entry rules, security deposits, and notice requirements. I'll also talk about good or just cause and rent control. So just really briefly, good/just cause means what are the valid reasons why a landlord can evict a tenant.
What's his name?
Then I'll discuss fair housing rights and housing discrimination when it comes to renting, whether a tenant is currently renting a unit and also for prospective tenants. Then I will talk about the rental process and credit reporting. So what folks should know about credit reports and when somebody is renting or trying to rent an apartment, what might show up on a credit report, how to challenge the reports that a landlord might rely on in making a rental decision. And at the end, I will provide some additional tenant resources geared towards Alameda County, and then we'll leave time for questions. Okay, so this is kind of just a summary of what I'll talk about in terms of basic tenant rights. So as I mentioned in the last slide, habitability, limitations on landlord entry, security deposit, what to know about when a landlord can deduct from a security deposit and what are the requirements for that process. Tenants' right to notice for different types of evictions, how much time the tenant has the right for notice, or, if it's the end of the lease, what are the notice requirements? Also, if a tenant wants to break their lease, what are the rules around that? Talk a little bit about the difference between month-to-month leases and term leases. Also, the opportunity to cure. If a tenant does receive an eviction notice, there should be a cure period in most cases. So, for example, non-payment of rent, tenants have a certain amount of time before the landlord can proceed with an actual summons and complaint. Before COVID, it was 3 days. It would be called a notice to pay rent or quit, but now, and I'll talk about this briefly, with the Alameda County eviction moratorium, tenants have a longer time in order to respond to a notice to pay rent. And there are some additional requirements with the Alameda County eviction moratorium. Okay, and then we'll talk about statewide just cause and rent control as well. Okay, so habitability. A lot of this is probably straightforward, but unfortunately, sometimes landlords do not follow these basic requirements. So tenants have the right to live in a habitable residence, and landlords are legally required to provide habitable rental units, which includes that the unit must be free of mold, asbestos, and lead, have safe and intact structural elements, including stairs, walls, roof, plumbing, electrical, etc. Landlords must provide heating and hot and cold water, have sanitary clean conditions, including pest and vermin control. And landlords must take reasonable measures to prevent break-ins and criminal activity on the property. That can include making sure that the locks work properly, and if it's perhaps there's a gate, so ensuring that there's appropriate security, passwords, that sort of thing. And if a tenant notifies a landlord of major repairs needed or another major habitability problem, for example, a rodent issue or a serious plumbing issue, and the landlord fails to fix the problem timely, the tenant may be able to withhold a portion of the rent or the full rent, depending on the severity of the issue, until the landlord fixes the problem. Or the tenant can pay for the repairs themselves and deduct a portion of the rent. And then the tenant should make sure to provide receipts to the landlord if they intend to repair and deduct. This option here is pretty serious. So the issue has to be really serious. It can't be something like, a broken drawer. It has to be, sewage problems, flooding, rodent issue, and the landlord, there has to be notice that the landlord had about the problem. And ideally, the tenant documents all of this in writing. So sends letters to the landlord, emails, text message even, but typically, emails and letters are a little bit more reliable in terms of, having a date stamp and that sort of thing. Especially if the landlord and the tenant have an email relationship, it's always best to be able to provide a letter, certified or return receipt or tracking, to be able to provide proof. But in addition to that, an email is a good option because of the date and timestamp. And the tenant should just make sure to document the problem really well. So taking pictures, and as I mentioned, communicating with the proper staff in writing. And then depending on the extent of the habitability problem, the landlord may be required to relocate the tenant temporarily and pay for hotel costs while the unit is being repaired. Okay, so when and why can a landlord enter the tenant's unit? In general, the landlord must give quote unquote reasonable written notice, and it's generally the consensus is that reasonable is 24 hours. Reasonable written notice to enter the tenant's unit Usually the reason might be to make agreed upon repairs, to show the unit to a prospective renter, or to do a pre-move out walkthrough. In limited circumstances, the landlord can enter the unit without prior notice. So this can include an emergency that requires the landlord to enter. The landlord obtains a court order, the tenant has abandoned the unit, or the tenant consents. And it's important to be mindful of excessive attempts by the landlord to enter the unit, as this could be an indicator of harassment, retaliation, or discrimination. I'll talk a little bit more about some of the state's anti-harassment laws later, and what options a tenant might have if that were to happen. But it's definitely something we've seen a fair amount at HERA. We have a case now actually where the landlord has gone into our client's unit repeatedly without notice or without the client's permission. So it's definitely a problem, unfortunately, and can affect folks who are vulnerable in some way, so elderly or people with limited English proficiency. So definitely something to be aware of. Okay, so now more on security deposits. To begin with, there is a limitation on the amount of a security deposit. For unfurnished apartments, the cap is 2 times the rent. For furnished apartments, it's 3 times the rent. And a landlord can only deduct from the security deposit for damages beyond ordinary wear and tear. So for example, a landlord can't require a tenant to pay the unit, paint the unit, or pay for the paint job unless there's damage to the walls beyond normal wear and tear, which could, for example, be a hole in the wall caused by the tenant, or if the tenant or a guest painted on the wall. So ordinary wear and tear is just kind of generally it's kind of how a unit would kind of over the course of time, there might be some expected wear to the property. So maybe carpets would fade or the wall would fade, that sort of thing. And cost to clean the unit to make it as clean as it was when the tenant first moved in, and then to cover unpaid rent. So generally, we definitely recommend that when tenants first move into a unit, taking pictures before they move everything in, possible. So maybe taking pictures if a tenant does a viewing and then gets to the apartment, taking pictures to see, what the conditions are before the tenant moves in, and then when the tenant does full cleaning and moves out at the end of the lease, definitely making sure to take pictures at that point as well. So if there is a security deposit dispute, hopefully the tenant will be able to show that the before and after are the same. And the landlord must return the full or a portion of the security deposit to the tenant within 21 days after the tenant moves out. And then if the landlord doesn't follow the security deposit process rules, which are in Civil Code section 1950.5, the landlord does face the possibility of double damages for the unlawful retention of the security deposit. So if a landlord does deduct a portion of the security deposit, the landlord must send the tenant any remaining refund, a written letter explaining the deductions, an itemized list of deductions, and copies of receipts unless the repairs costed less than $126, or the tenant agrees that the landlord does not need to provide receipts. We see issues around security deposits a lot. Like I rarely seen a landlord follow these requirements, unfortunately, when they retain a portion of the security deposit or the full security deposit. So there could potentially be a lot here if the the tenant did not receive a written statement or didn't receive copies of receipts, there's definitely a lot that the tenant or a legal aid lawyer or somebody could help the tenant dispute. Most of the time, from what I've seen, that any small claims actions or any lawsuits that tenants might file are in small claims court. So lawyers would not be allowed, but we try to help tenants in this situation kind of prepare a packet themselves. And I haven't had a client yet who has actually gone to small claims court yet for a security deposit issue, but I've helped in terms of preparing a packet. Okay, so basic tenant rights related to notice and termination requirements. The landlord must provide a tenant with prior written notice in order to evict for any reason. And as I touched upon earlier, so Alameda County and the City of Oakland still have a COVID-19 eviction moratorium in place. I'm not going to get into all the details about that in this training, but some folks might know that the state of California had an eviction moratorium for non-payment of rent cases, but that expired at the end of September. However, Alameda County and the City of Oakland, their moratoria are still in place, and it's pretty restrictive in terms of what types of evictions are allowed. Only for Alameda County, public health and imminent public health and safety evictions, removal of the property from the rental market. So that's known as the Ellis Act. Or if the unit must be vacated to comply with a government agency or court order. Those are the only evictions that are allowed, but there's also if there's a non-payment of rent, if the issue is a non-payment of rent, tenants in Alameda County have to provide a response within, I believe it's 15 business days. I could be incorrect about that. I'd have to go and double check. And there has to be a connection to COVID-19 in terms of the tenant's difficulty to pay rent. Oakland also has an eviction moratorium in place, and it's even more restrictive than Alameda County. So it only allows for evictions for imminent public health and safety and removal of the property from the rental market. So the Alameda County eviction moratorium expires 60 days after the end of the local emergency. And last I checked, which was yesterday, we were still in it, according to this web page is good. This is where I go generally to check on the status of Alameda County's eviction moratorium. So I've provided a link here. And then here's a link for the City of Oakland's COVID-19 eviction moratorium and updates there. So I definitely check back at those links in case you're watching this at a later time. And I will be providing the slides after this training, so you'll be able to keep them. Okay, so a cure period, as I stated earlier, in most cases, the tenants have what's called a cure period after a non-payment of rent notice or lease violation. And so it's a notice and the amount of time before a landlord can file an eviction lawsuit and serve the tenant. However, if the violation is egregious, for example, nuisance, or the tenant has caused substantial damage to the property, or there's criminal activity on the premises, a cure period isn't required, and the tenant may be required to vacate the unit within a certain time frame. Usually that's about 3 days without the opportunity to fix the issue. Now, so for notice of termination of a lease, for a month-to-month lease, if the tenant has been living in the unit for at least 30 days, the landlord must provide the tenant with 30 days written notice. If the tenant has been living in the unit for more than 1 year, the landlord must give 60 days written notice. And for a fixed term lease, so for example, 1 year, which is the most common lease that I've seen for fixed terms, In most cases, the landlord cannot terminate the lease without cause, which means without a reason, before the end of the term. The lease will change to a month-to-month tenancy at the end of the lease term, unless the landlord and the tenant agree to renew for the initial lease term. The end of the lease does not constitute just cause, which I'll get into later, but the tenant risks eviction for refusing to sign a new lease with the same terms. Okay, I'm going to talk a little bit about a law that it was initially drafted for domestic violence and elder abuse survivors, but has recently been expanded to include certain crime victim survivors that don't have a domestic violence relationship or elder abuse. So this is in Civil Code section 1946.7, and under this law, domestic violence and elder abuse and certain violent crime survivors, as well as stalking survivors, can end their lease early. Sorry, I just need to make this. Without having to pay a fee, so they can break their lease if they inform their landlord and provide any of the following documents: a police report, temporary restraining order, or a restraining order after hearing, a letter from a qualified third party, such as a domestic violence counselor, any other document that, quote, reasonably verifies the abuse or the crime occurred. So for example, some sort of proof showing threatening emails or text messages from the abuser or stalker, or, you know, whoever the perpetrator was. So usually in cases like this, I would help the person seeking to end their lease early with a letter. There's kind of like a standard form and letter that folks can use. And actually on, if you go to Ledge Info, California Ledge Info, and just look up the code, Civil Code 1946.7, there's sample text. And I'm pretty sure some other organizations have sample letters. We might have some, and I'm sorry, I can't think off the top of my head which organizations might have some updated letters. But yeah, folks are interested in that, definitely feel free to let us know. And then so the tenant is still responsible for paying the rent for no more than 14 days after providing notice to the landlord under this law. And the tenant should be reimbursed for any extra money paid to the landlord. So for example, if the tenant paid for the whole month of rent, and let's say they gave notice on July 1st, they would only be responsible for rent until July 15th. So they should get the reimbursement for that second half of the month. So now I'm going to talk a little bit more about just cause and rent control. So locally, cities can enact ordinances to protect tenants from displacement. In Alameda County, cities that have done so at varying levels are Berkeley, Emeryville, Hayward, Oakland, Alameda, Emeryville, Union City, and Fremont. So there are different processes for what happens when a landlord tries to increase the rent. And that there at the local level, there's a process called rent review and mediation and rent stabilization. So stabilization is determining if a rent increase goes beyond the local rent cap or rent control level. And there's also a process whereby tenants can dispute or challenge rent increases by the landlord. So Berkeley, Oakland, Alameda, Hayward, and Fremont have more information about how tenants can engage in this process. All of the city's websites on their housing department should have information about the rent review process. So these cities, Berkeley, Emeryville, Oakland, Hayward, Union City, and the city of Alameda also have just cause, which means that landlords can only evict for certain specified reasons. So if a landlord tries to, there are some exceptions, but if a landlord tries to evict for a reason that's not on the list, that would violate just cause. And then in some cases, if there's a habitability problem not caused by the tenant, the landlord may be required to pay for relocation expenses for 1 month if the tenant must vacate. So statewide just cause, this is in the Tenant Protection Act or Civil Code 1946.2. This was in 2019. So generally there are two types of just cause. One is no fault just cause and the other is at fault just cause. So under no fault just cause, it's what it sounds, the tenant hasn't done anything to violate the lease in any way, or they haven't, for example, committed a crime on the property. So what this often looks like is the owner or the owner's family member wants to move in. So under the state law, that can only happen if it's in the lease or the tenant agrees in writing. Also, the intent to demolish or substantially remodel the property. The landlord withdraws the unit from the rental market. Again, this is the Alice Act. In order, and then an eviction in order to comply with a court order related to habitability. And then at fault just cause is again what it sounds like. The tenant has violated a material term of the lease or engaged in other specified actions. So for example, non-payment of rent, criminal activity on the premises, and refusal to allow the landlord to enter lawfully. So it's important to note that the Tenant Protection Act, just cause protections do not apply to all tenants. And then also because of the Alameda County eviction moratorium and the city of Oakland's eviction moratorium, not all of these reasons are, not all of these reasons for just cause evictions are allowed right now in the county, but that will change when the local emergency expires in Oakland, and then 60 days after the end of the local emergency for the full of Alameda County. So here is the list of exceptions to the statewide just cause rule. Folks staying in a transient and tourist hotels, housing in a nonprofit hospital, religious facility, extended care facility, etc., student dorms, a duplex where the landlord lives on the property, if the unit was built in the last 15 years, a single family home not owned by a corporation, real estate investment trust, or an LLC with one or more corporate members. This one down here, it gets kind of tricky. I've had clients in Oakland who weren't protected by just cause because they lived in a single family home that was owned by an LLC that did not have one, sorry, it's even confusing as I say it. So it was owned by an LLC. This client's home, single family home, was owned by an LLC, but didn't have corporate members. So unfortunately, just cause did not apply to this family. So if a client or you know somebody, or you're here yourself and are interested in learning about your rights as a tenant, for single family homes in Alameda County, definitely that is a flag that I would recommend investigating more to figure out if the person is covered by just cause at the state level. And if they're not, the landlord still has obligations to follow a certain process in terms of notice requirements for eviction. And then also, if the tenant shares a bathroom and a kitchen with a landlord, those units are not covered by just cause. Okay, so rent control under the state law. This is in Civil Code 1947.12. Rent cannot be raised by more than 5%, plus the local consumer price index, or 10%, whichever is lower. And this rent cap will expire January 1st, 2030. So folks can find the CPI on local housing agency website. So for example, the city of Oakland has their updated CPIs there. There's a link. And then also the US Bureau of Labor and Statistics. It's the CPI for San Francisco Bay Area region, which includes Oakland, Hayward, San Francisco, and a few other cities. So you can find that, the consumer price index there as well. And rent can only be increased twice in any given 12-month period. Again, the landlord must provide proper rent increase notices to tenants. And then there are also exceptions here to rent control at the state level. And it's the same list of exceptions for just cause. So tourist hotels, hostels, nonprofit hospitals and religious facilities, extended care facilities, student dorms, a duplex where the landlord lives on the property, housing restricted by a deed, regulatory restrictions. So this is generally public housing and housing for low and moderate income households. And again, the single family home category and certificate of occupancy that's less than 15 years old. So now some more information about California tenant laws in relation to retaliation. Under Civil Code Section 1940.2, landlords cannot threaten tenants, engage in, quote, menacing conduct constituting a course of conduct that interferes with the tenant's quiet use and enjoyment of the premises, use force or threaten to use force against tenants, threaten to release information about tenants' immigration status. I'll talk a little bit more about immigration status later when we talk about fair housing. And there are several penalties for up to $2,000 for each violation. So for example, here, if a landlord repeatedly goes into a tenant's unit without notice or permission, that could count as harassment and menacing conduct. There's also the Bain Act, which is Civil Code Section 52.1A, and this protects people from the interference, threat, or coercion for exercising their legal rights, and penalties for up to $25,000 for each individual whose rights were violated against the defendant. So let's say in this case, the landlord has violated the statute. So if a tenant is, for example, I'm trying to think of a case that I've had. I had one case where the tenant was illegally locked out of her unit. The landlord turned off the water for no fault of the tenants without giving the tenant notice. And she was an elderly woman and had to leave the unit during COVID. She sought help and called the police to help her get back in. So if the landlord had retaliated against her in some way for exercising her legal rights and calling us and getting legal help, maybe the landlord tried to, just thinking of an example, this didn't end up happening, but let's say if the landlord sued her for water damages as a result of this issue, that could be an example of a retaliation. And then also it's important to check local ordinances. The city of Oakland has the tenant protection ordinance, which is pretty strong, and there are additional requirements that landlords would have to follow. Okay, so now let's switch gears and talk about fair housing rights under federal and California law. So the red here, the red text is federal and state law, and the blue text is just California, but this describes all of the protected classes or factors and reasons, characteristics based on which landlords and providers of housing cannot discriminate against people. So under federal and state law, it's unlawful to discriminate in the provision of housing because of race, religion, color, sex, including pregnancy, childbirth, or medical conditions relating to them, as well as gender and the perception of gender, sexual orientation, marital status, national origin, ancestry, familial status, disability, source of income, immigration status, medical condition, or age. I'll just add, actually, the Biden, I'll talk about this later, but the Biden administration did issue an executive order earlier this year stating that it violates the Fair Housing and Employment, sorry, that's California, the Fair Housing Act to discriminate against people based on sexual orientation. Even though the Fair Housing Act doesn't explicitly include sexual orientation, there is now an executive order by the federal government, so that will help more. But sexual orientation is protected under California law, but having the Biden executive order will help to just kind of further leverage cases involving sexual orientation discrimination. And then so for California, the laws that apply most oftenly are the Fair Employment and Housing Act and the ENRU Act. I don't think I included the citations, but I can share them now just since they're being recorded. So it's government code. The Fair Employment and Housing Act is government code 12900 through 12996. And then the ENRU Act is Civil Code Section 51. Okay, so who has to follow fair housing laws and when do they apply? So the provision of housing is fairly broad, but for our purposes, it applies in renting and leasing. So not only when someone has already started their lease, but before renting a place. So if a person is searching for a rental and applying for rental properties, fair housing laws apply at that stage as well. Sales of property, mortgage lending and insurance, advertising, including for rental property, and homeowner association actions. So there's two ways to expose discrimination: disparate treatment and disparate impact. Probably not very surprisingly, it can be harder to prove discrimination if a landlord just doesn't outright say, oh, I only rent to white tenants, for example. We don't see that very often in the work that we do. Usually it's more subtle than that. So that can be where disparate impact comes into play. But just kind of generally, some examples that might be an indicator of discrimination before I get into more detail about disparate treatment and disparate impact. So for example, let's say somebody is trying to rent an apartment and they're a person of color, and perhaps all of a sudden the landlord says an apartment has already been rented, even if it's still being advertised online, refusing to show apartments or houses in certain neighborhoods or buildings to tenants of a certain race, providing inferior terms or conditions to, for example, families with children, harassing a person in connection with housing, or failing to remedy harassment by another tenant, which I'll talk about a little bit later. So for example, sexual harassment against women, that could be an indicator, that would be an example of fair housing violation based on gender. let's see, or canceling a rental agreement once the landlord finds out a certain factor about somebody. I had a client where they were initially told that a Section 8 voucher was allowed, and when he went in person to provide his application, he was a person of color, then he was told Section 8 was not allowed. So, you know, that was a suspicious indicator of discrimination based on race. And then also refusing to allow a person with a disability to make a reasonable modification to a unit or a reasonable accommodation, which I'll get into later, for example, in relation to the rental process or applying. Okay, so now a little bit more about proving discrimination. So disparate treatment is intentional discrimination. So let's say that the landlord has a policy of only accepting single people, doesn't accept families, and they have that written. That would be an example of intentional discrimination. Disparate impact. This is a facially neutral act or practice. I'm sure a lot of you all already know this, but that resulted in a disparate impact on a protected class. So let's say they have a neutral policy that's on its face is not discriminatory, but for example, the landlord only accepts tenants who have a certain credit score or above. We've seen this recently, actually. That policy of only accepting tenants of a certain credit score, certain minimum credit score, can have a disparate effect or differential effect on, for example, women of color. There is more involved with disparate impact in terms of proving. So in disparate impact cases, the plaintiff must show that the proven, first, it's helpful to be able to research and provide statistical analyses and differences showing how a protected class is affected versus the control group. Or the individuals who are accepted into the apartment, for example. So the plaintiff must show that the proven statistical disparities are actually caused by the policy being challenged. And then the next step requires the defendant, so the landlord, to prove that its challenged policy is needed to advance a legitimate interest. And then the burden would shift, or sorry, also the defendant would have to, the plaintiff would have to indicate that the interest could be served by another practice that has a less discriminatory effect. So with disparate impact, it's a way to prove discrimination when oftentimes, you know, in our society, people conceal their true motivations in making, for example, rental decisions in this case. And also, I'll give some examples of cases regarding disparate treatment and disparate impact. So in one case, this is a disparate treatment case. 3 Latino and 2 white current and former tenants sued building owners. The plaintiffs alleged that the landlords discriminated against Latino residents living in rent-stabilized apartments by requiring only Latino tenants to provide proof of their legal immigration status, but by not requiring tenants who were not Latino or Latina to provide immigration information. The landlords would also threaten and intimidate these Latino tenants and impose unlawful rent increases. This case survived a motion to dismiss. A disparate impact case example. This also included disparate treatment, but the disparate impact piece of it was that the tenants of this rental complex were primarily Black, and the landlords imposed restrictions implemented by the previous owners, which included restrictions on the children's use of the grounds at 10 p.m. and a 10 p.m. curfew. And then, so the disparate impact component of this case was that the landlords imposed a rule barring anyone who had certain felony or misdemeanor convictions within the last 99 years from living in this complex. So the plaintiff tenants alleged that the rule about the 99-year conviction requirement had a disparate impact on them due to their race, and it was also arbitrary. And in this case, the plaintiffs were able to survive a motion to dismiss on the disparate impact claim and the intentional discrimination claim. Talk a little bit about fair housing and domestic violence. So at the federal level and state, status of someone as a domestic violence survivor is not a protected class, but oftentimes people have used the fact that domestic violence survivors are majority women, and so connect that to fair housing laws protection of women in the protected class categories. So in California, the eviction of or discrimination against a tenant from any housing because of their having experienced domestic violence may be considered discriminatory. Again, it's best to connect it to the fact that majority of domestic violence survivors are women. In California, landlords cannot evict tenants based on their status as a domestic violence survivor, and cannot evict tenants for police responses to the property based on domestic violence incidents. This is California Civil Code section 1946.8. And then familial status, so it's violate Fair Housing Act and California law to discriminate against people based on their familial status. So it prohibits discrimination in housing against families with children under 18. It can also look like the refusal to rent to unmarried couples, unreasonable occupancy limits, and imposing special rules or treating people differently or worse than households without children. For familial status discrimination, I've seen, I had a client once where there was an occupancy limit of just one person and he got married. And so he wanted his wife to move in with him. So there was concern that, that would violate the occupancy limit, which our argument was that it would be discriminatory based on familial status, having this one person occupancy limit. Okay, so immigration status. Landlords cannot ask prospective or current tenants what their immigration status is. This is all in Civil Code section 1940.3. Landlords cannot disclose to another person or entity information pertaining to the immigration status of a tenant, prospective tenant, occupant, or prospective occupant. For quote unquote, for the purpose of or with the intent of harassing or intimidating the tenant, these individuals retaliating against a tenant or influencing a tenant to leave the unit. So yeah, there has to be kind of, you know, some sort of intent to influence the tenant in some way. I haven't seen this very much, but I'm not sure if it comes up, but it's definitely something to be on the lookout for. Okay, so source of income. This is a California law specifically. In California, landlords and other housing providers cannot reject prospective tenants based on their source of income. For example, if a tenant receives a Section 8 voucher or other public housing assistance, prospective landlords cannot deny the rental application based on this fact. And it's also important to note the source of income discrimination can be a pretext for other unlawful discrimination. So this can also include if a tenant receives financial assistance from a third-party organization, for example, that would also apply in this case. So landlords would not be able to discriminate against a tenant if she, for example, receives financial assistance from a nonprofit. Here's an example down here. A prospective tenant applies for an apartment and the landlord tells him they accept vouchers, but then the person is only approved and goes to drop out the paperwork. This is an example of the case I had. So in this case, the prospective tenant was a person of color, and then they went to drop up the paperwork and the landlord said they did not accept vouchers. So it would be, in that case, an indicator of discrimination based on source of income as well as race. Okay, so here's some more information about Biden's executive order regarding sexual orientation. On February 11th, 2021, the Biden administration issued an executive order stating that the administration will enforce the Fair Housing Act as applied to individuals based on sexual orientation and gender identity. In other words, what this means is that the executive order makes it illegal under the Fair Housing Act to discriminate against people in housing based on their sexual orientation and gender identity. So if a tenant believes they are being discriminated against based on these factors, they will likely have a stronger legal claim. So here's just some more information on the White House website where you can find the executive order. And as I mentioned before, sexual orientation was already a protected class for housing in California before the Biden executive order, but now those claims would be even stronger.
How would you go about proving discrimination against sexual orientation if people are not overt about it?
That's a good question. They're always these cases can be hard to prove because sometimes the evidence is circumstantial. So one thing that we recommend is there are fair housing agencies that use individuals, which is called testers, or it's a process called testing. So they'll have individuals who work for the fair housing agency go to the housing provider, let's say if they're trying to rent an apartment. So if someone believes they're being discriminated based on their sexual orientation, it might make sense to get in touch with a fair housing counselor who does testing. So essentially what they would do is they would get other people to go to the landlord and try to do a viewing and that sort of thing, and see, they have all the exact same credentials as other tenants who are not, who the landlord presumes are straight. Obviously, it can definitely be if somebody doesn't outright say what the sexual orientation is, which probably is not very common. It is harder to prove, but the landlord, this would also apply based on the landlord's perception. So maybe the tester, has two people who are have completely the same credentials, and then kind of see if there are any indicators of discrimination by the landlord. But it's definitely, it can be tricky for sure if there isn't kind of explicit discrimination or something in writing. But if there's, if somebody had, definitely bring a witness. I would recommend, regardless of what the protected class is, having a witness would also be helpful. And then these fair housing counseling agencies they don't just do testing, they also have other ways to try to suss out discrimination and to help someone build a potential claim. Okay, so some more information about sexual orientation discrimination in California and federal law. So it prohibits intentional discrimination by a landlord against a tenant, again, based on a protected characteristic. There's also requirements that a landlord must follow based on tenant against tenant harassment. So if a landlord has actual notice of a tenant harassing another tenant based on a protected status, the landlord must take reasonable steps within its control to stop the harassment. Okay, so tenants experiencing discrimination or harassment from another tenant, for example, ethnic slurs, they have a strong argument that the landlord is obligated to intervene and stop the other tenant's behavior as long as the landlord has adequate notice of the other tenant's conduct. That intervention by the landlord can include measures up to eviction of the other tenant. So this is also based on the fact that tenants have the right to the quiet use and enjoyment of their residence. And if they're being harassed by another tenant or discriminated against, and the landlord has notice of that, the landlord has a duty to protect tenants' quiet use and enjoyment of their residence. So the landlord would have to take action at that point to ensure the tenant who's making the complaint has their right to the quiet use and enjoyment of their unit protected. And if the landlord doesn't do anything to resolve the situation, even though they know about it, tenant might have legal claims against the landlord. There is a case I just wanted to talk about briefly about sexual orientation discrimination and tenant against tenant harassment. So this was a Seventh Circuit case in August 2018. This case involved a woman. So the case is called Wetzel versus Glenn. And it involved the case of a woman who moved into a living community. And she said that after she moved in, she was subjected to physical and verbal abuse from other tenants because she was openly gay. She claimed that she routinely reported the abuse to the St. Andrews staff, which is the the housing complex, but they told her not to worry about the harassment and dismissed the conduct as accidental. And they denied her counts and just told her that she was lying. So in that case, the Seventh Circuit held that in addition to creating liability when a landlord intentionally discriminates against a tenant based on a protected characteristic, the Federal Fair Housing Act also creates liability against a landlord that has actual notice of tenant-on-tenant harassment based on a protected status, but chooses not to take any reasonable steps within its control to stop the harassment. Okay, so now I'm going to talk a little bit more about reasonable accommodations and disability discrimination. A housing provider must allow a person with a disability to make reasonable modification to the rental unit. So reasonable modification is, for example, expanding the hallway to fit a wheelchair, or making structural changes. If it's not a federally subsidized unit, then the tenant would have to pay for the modification. But if it is public housing, for example, or the tenant has a voucher, Section 8 voucher, then the landlord would have to pay for the modification. The housing provider must also make what's called reasonable accommodations and rules, policies, et cetera, to allow a person with a disability the equal opportunity to use and enjoy a dwelling. So in order to be able to get a reasonable accommodation or modification, the tenant must show that a requested accommodation may be necessary. There must be an identifiable relationship between the requested accommodation and the individual's disability. So the tenant doesn't have to provide specifics about the disability, just so that they are protected under the American with Disabilities Act. Because of a condition, a disability, they definitely don't have to get into specifics. And then the landlord must engage in an interactive process with the tenant. So the landlord can't just deny a tenant the reasonable accommodation request without further engaging in with the tenant to understand what the needs are and why the tenant needs this accommodation or modification. So here's a sample letter that folks can keep. It's just stating where the tenant lives, their address. I am a qualified individual with a disability as defined by the Fair Housing Amendments Act of 1988. Let's say this was an issue related to a building rule. Then the tenant will want to say, because of their disability, I need XYZ. So the accommodation could be, for example, more time. I had a client who needed more time to move out his belongings for an inspection because of his physical disabilities. When I should add that this also applies to mental health disabilities. So disabilities that aren't necessarily obvious to everyone. And you can, tenants can also provide letters from doctors or healthcare providers to kind of shore up the request. And then just finishing up with a line saying, it's unlawful to discriminate based on a disability, and then definitely engaging in the back and forth process. I'm not sure how many landlords know that they're required to engage in this interactive process. We've seen a number of times where the landlord will just automatically deny somebody a reasonable accommodation request without explaining why, or asking, you know, how it can be modified if the landlord does have a legitimate issue. Okay, so service animals in the Fair Housing Act. Under the Fair Housing Act, tenants must show the accommodation of a disability need is needed to afford an equal opportunity to use and enjoy the premises, and the accommodation is reasonable. So this also can include assistance animals, whether it's a service dog or an emotional support animal. And again, the landlord may ask for a documentation of a disability and the disability related need for an assistance animal. And the landlord can ask that for that documentation, but can't probe too far. So again, even in this case, the tenant might not necessarily need to provide specifics about the disability, but having a letter from a doctor or psychologist would help to provide that documentation. Okay, so fair housing and criminal record. It's not an automatic disqualification of an applicant, rental applicant, for having a criminal record. However, landlords are allowed to impose some restrictions, and having a criminal record is not protected class under state and federal anti-discrimination laws. In California, there are regulations in place related to criminal records and fair housing. So a housing provider's policy or practice regarding criminal history will violate California law when it has an unjustified discriminatory effect on members of a protected class, even when the provider had no intent to discriminate. So this is essentially this disparate impact policy. So you can find more at this report here, and then California Code of Regulations. I've provided the citations down there. Be mindful of time. I might have to go a little bit fast for the rest of the presentation to make sure we have time for questions. Okay, so housing discrimination and COVID-19. Just wanted to talk a little bit about everything that has been going on the last year and a half with COVID-19. And I'm sure a lot of people can imagine, research is showing that COVID-19 is having a disproportionate impact on people of color, and there are multiple reasons for this, including longstanding discrimination in healthcare access, housing and employment, poverty, and unequal access to economic mobility. In housing and rentals, discrimination during COVID might show up as using eviction moratoria as exceptions, eviction moratoria exceptions as a pretext to evict tenants for discriminatory reasons. Landlords not granting necessary reasonable accommodations to people with disabilities, including people who contract COVID-19. A landlord cannot require prospective tenants to disclose whether they have COVID-19. Also, COVID-19 is not a valid reason to evict somebody under the public health and safety exception of the Alameda County eviction moratorium. Also, it can look like senior and elderly tenants experiencing higher rates of stigmatization and harassment from landlords or other tenants, or Asian tenants and prospective tenants experiencing similar behavior by landlords and other tenants. And then, as we've seen, hate crimes and harassment against Asian tenants. Okay, so these are some signs to look out for in relation to renting and potential discrimination. The landlord denies a person's rental application without providing a reason, or provides a vague reason, for example, credit, with nothing in writing. The landlord drags out the rental application process. The landlord's tone and treatment towards the prospective tenant changes once the landlord has seen the person seen the prospective tenant in person or has talked to them on the phone. So for example, maybe the prospective tenant has an accent that's obviously from another country, or as in the case with my client, the landlord sees them in person and sees that they're a person of color. Or you notice that your landlord or property manager responds to other tenants' requests to fix the unit issues faster than they respond to you, or treats tenants of a certain race or gender, for example, differently than other tenants. So here are some steps to take for folks who might believe they're being discriminated against, or if you have clients in these positions. Just, you know, of course, as I've already mentioned, it's good practice to make sure communications with landlords are in writing as much as possible. And for example, if an application is denied and you didn't receive a reason in writing, write to the landlord and ask for a reason. And if they don't provide anything, that, you know, that is an interesting kind of potential indicator that something more might be going on there. Of course, document as much as possible, as I've already talked about. Take pictures if relevant. Log discriminatory incidents with date and time, keep all written records, and then bring somebody. For example, if you're going to communicate with your landlord about something, it's in person, make sure to have a witness if you can, or maybe a neighbor. And then, as I've already talked about a little bit, reaching out to fair housing organizations that provide testing could be an option. And then if you're interested in kind of what your legal options are, definitely calling a legal aid organization or a fair housing lawyer to learn more about what your options might be and the strength of your case. So I'll talk a little bit about filing agency complaints with California, the Department of Fair Employment and Housing, or the Federal Department of Housing and Urban Development, or HUD. And then also, you know, as the most escalated option is filing a lawsuit. Okay, so as mentioned, folks who have believe they've been discriminated against can file a lawsuit or file a complaint with HUD or the Department of Fair Employment and Housing. Filing a lawsuit should be within 2 years of the conduct. And then this is a general process for filing an agency complaint. So first filing kind of a summary, a written history explaining what happened and what the discrimination was, and providing any evidence and documentation. Then there will be an intake process where a staff member at one of these agencies will you know, ask you questions, ask the complainant questions, and assess the case. And then they will begin the investigation process and conciliation, which means they'll reach out to the other side and investigate all the documentation and talk to any witnesses. And then at this point, sometimes the agency staff will try to get both sides to come to some sort of settlement agreement. If that doesn't happen, then the agency will either determine that there was discrimination, which is a reasonable cause finding, or find that there was not discrimination or no cause. And then so if there is reasonable cause finding, then HUD would represent the individual in a lawsuit, and if there's no cause, then the individual can go and file their own lawsuit. This is just a screenshot of the HUD website and how to file. How to file a complaint. This is the process for California Department of Fair Employment and Housing. So you can file it online, by mail, by phone, or by email. And here's a link to more information about the process. Okay, so now we're going to switch gears and talk about the rental process and credit. Tenants have the right to request a copy of their credit or tenant screening report a landlord uses when deciding whether to rent a unit to someone. Prospective tenants should request a copy of the report in writing. Also, depending on where a person applies for a rental, sometimes if it's online, I've seen options to just like check a box to receive a copy. For credit report, definitely recommend that. And then if a landlord denies someone's rental application, at least partially based on credit or the tenant screening report, the landlord must provide a letter stating that the denial was partly or entirely based on credit or the screening report, and provide the contact information of the reporting agency, and include a statement that the prospective tenant has the right to obtain a free copy of their credit report that prepared the report that the landlord relied on, and to dispute the accuracy and completeness of the information in the credit report. Okay, so now a little bit more about what can be reported on a credit report. So when can an eviction be reported on credit? Generally, only if the landlord gets a judgment, meaning the landlord wins, within 60 days of filing the unlawful detainer, or upon order of the court. And then with COVID-19, the state passed kind of some special protections related to non-payment of rent evictions that happened between March 1st, 2020 and October 1st, 2021. So no non-payment of rent cases that occurred during this time frame, regardless of who won the case, can be reported on a tenant's credit report. However, unpaid rent during COVID can be reported on a tenant's credit reports. So here are some additional tenant rights resources. HERA, so as I mentioned, we can't provide eviction defense services, but we help out tenants on a whole host of other rental related issues, and then also people who may be homeless or are trying to find new housing and are having issues with the rental process. So here are some other Alameda County organizations: Eviction Defense Center, Centro Legal de la Raza, East Bay Community Law Center, and Bay Area Legal Aid. So these 4 organizations do have eviction defense services. So if your client are dealing with an eviction notice, definitely contact them as soon as possible, because there are requirements and a pretty time-sensitive timeline for how an eviction case will go. Here at the bottom are a couple other resources for tenant rights information: Alliance of Californians for Community Empowerment, and then Tenants Together. I believe they're based in San Francisco, but they have a hotline and have a lot of information on their website. So I believe they serve individuals beyond San Francisco, at least in terms of providing information on the phone and that sort of thing. Okay, and then just one more. And then just as a final slide, here's some more information about HERA's services and our other areas of practice. Everything except estate planning is free, and we focus on lower income communities. Estate planning, I believe it's a sliding scale, but definitely if you have any questions or you have clients who have questions, definitely feel free to direct them to our website or give us a call. We do have attorneys who can speak with folks to do an intake call, and kind of depending on the need of services, it can be, as short as like 1 hour, consultation, or providing more in-depth services such as writing advocacy letters, that sort of thing. We don't represent individuals very often, so it's generally more helping folks kind of understand what their rights are and advocating with their landlord. So that's just summary of what we do. If we have a few more minutes left, so I'm happy to see if I can answer a couple questions.
There were a few questions in chat. One was, can a tenant be evicted for getting drunk or high too often, where there's like no domestic abuse or violence involved?
Based on like just that fact, I don't think so. I mean, it's kind of up to the landlord. It would be up to the landlord to try to prove that it's causing like a nuisance or, public health issue. At least in Alameda County right now, we do have that eviction moratorium. But if it's violating the lease, it's something that, the tenant will want to be aware of, that, technically maybe if it's violating the lease, the landlord can try to evict, or if it's causing a nuisance, issue for other tenants, for example, smoke in the unit, it's definitely something that could be a concern for a landlord, but I'm not necessarily sure that it would automatically be a reason to evict.
Let's say thank you. Another question was, did you talk about like retaliation for requesting repairs?
Oh, I didn't, but yeah, that's definitely a problem. If a tenant is requesting, repairs, and it's not, the habitability problem is not caused by them, if the landlord retaliates against the tenant in some way, I mean, I'm not exactly sure what this example, like what the retaliation looks like, but yeah, that's definitely a concern, and would be the tenant might have, it could support the tenant's case that the landlord is behaving potentially illegally.
All right, thanks. And there's one other question was, I think on the topic of, I guess, tenants harassing other tenants, I think. The question was, what if the harassing tenant is a member of a protected class, such as age or race or sexual orientation, or if there's an eviction moratorium?
I'm not sure I understand the question. So the tenant who is harassing the other tenant is also a member of a protected class?
I think so.
Yeah, I mean, I'm not sure. That sounds like a tricky situation. It might be a matter of sussing out what the facts are. If it's a he said, she said thing. Again, there are some exceptions to the moratorium. So yeah, it's a little hard to answer that question with the current facts, but I think it would be a question of figuring out, well, what does evidence look like on both sides. It doesn't make the harassing tenant doesn't kind of negate what they're doing. If they are harassing the other tenant, that's still something the landlord would have to address. Thank you, everyone.